In this lecture, we'll discuss about the Surrogacy Regulation Act of 2021. So, first we'll discuss about the definitions given under Section 2 of the Act. So, in particularly in those which are being defined under Section 2 of the Surrogacy Regulation Act of 2021 is what exactly altruist surrogacy means, then commercial surrogacy, then embryologist, then the definition of fertilization, then fetus, then implantations, intending couple, then intending women, surrogacy clinics, then surrogate mother. These are being defined under Section 2, and while Section 3 provides the provisions relating prohibition and regulation of surrogacy clinics, then Section 4 provides regulation of surrogacy and surrogacy procedure. Then Section 5 of the Surrogacy Regulation Act provides prohibition of conducting surrogacy. Then Section 6 provides regarding the consent of the surrogate mother. Then Section 10 provides prohibition of abortion. Then we'll discuss about the registration process of surrogacy clinics and the mandatory registration certificate of registration. And while Section 3 provides rejection, cancellation, and suspension of such surrogacy registration clinics, then Section 14 provides communication of such order regarding rejection, cancellation, and suspension, and the provision relating to appeal. And also will discuss about the national board or national registry or the state board or the appropriate authority. And finally we'll discuss one important leading case, and that is Karan Balraj Mehta and another versus Union of India, and that case was decided in 2022. So in particularly in Indian scenario, since it was then considered as unethical, immoral, and irreligious regarding the very idea of surrogacy, but subsequently, due to modernization, westernization, which led rapid urbanization of cities and towns, then there is the development of the idea of surrogacy, and finally in 2016 a surrogacy regulation bill was introduced and it was passed in Lok Sabha, the lower house of the Indian Parliament, proposing to permit only Indian heterosexual couple married for at least 5 years with infertility problems to access altruistic or unpaid surrogacy, and thereby banning commercial surrogacy. The 2016 bill, which was passed by Lok Sabha, was lapsed owing to the adjournment of the parliament session, so the bill was again reintroduced in 2019. So the Surrogacy Regulation Act finally enacted in the year 2021. This act explains surrogacy as a practice in which if a couple is incapable of producing a child of their own due to infertility or any disease, they are eligible for surrogacy process with certain guidelines. It is permitted only for altruistic purposes or for couples who suffer proven infertility or any kind of disease. So, what exactly altruistic surrogacy, which is being defined under Section 2 of the Act, which includes no money related pay to the surrogate or other than the clinical cost and protection inclusion during the pregnancy. So, in vitro treatment is the most widely recognized and powerful sort of the assisted reproductive technology. The Assisted Reproduction Technology Regulation 2021 gives a framework to the execution of the law on surrogacy by setting up the National Assisted Reproductive Technology or Surrogacy Board as it is provided under Section 13 and 14 of the Act. In order to improve the facilities provided in surrogacy clinic, the Ministry of Health and Family Welfare came up with surrogacy number of persons employed and the qualifications that they must possess. In addition to that, it also provides for the form and manner in which the registration will take place and the procedure to pay the fees for surrogacy clinic. So now we'll discuss about those circumstances for opting surrogacy. So when a woman has no uterus or missing uterus or abnormal uterus, or the uterus is surgically removed due to any disease, then the second important circumstance leading to or opting for surrogacy when it is felt to conceive even after multiple in vitro fertilization. So also in case of multiple pregnancy losses and the medical reason is unexplained, or if any circumstance under which a pregnancy is impossible due to some inherent illness. So now we will discuss all those key important points of surrogacy regulations as provided under the Surrogacy Regulation Act of 2021. The central government, by issuing a notification, declared the eligibility criteria and number of persons required at a registered surrogacy clinic. Further, the details for the minimum equipment required at such clinics are also specifically mentioned. Further, the composition of such clinics as per notification that any such clinics shall have at least one gynecologist, anesthetist, embryologist, and counselor, and clinic may employ additional staff by the assisted reproduction technology, level 2 clinics, and the other important need is the gynecologist at surrogacy clinic shall be a medical postgraduate in gynecology and obstetrics and should have record of performing 50 ovum pickup procedures and at least 3 years of work experience in assisted production technology clinic under supervision of a trained assisted reproduction technical specialist. So, it art is also defined as assisted reproductive technology with its grammatical variation and cognate expression means all techniques that attempt to obtain a pregnancy by handling the sperm or the outside the human body and transferring the same embryo into the reproductive system of a woman. And fourth, it is very essential for a gynecologist to have expertise in this technology of assisted reproductive technology. So, as under the very Act or the Regulation Act of Surrogacy of 2021 under Form 1 in the notification specifies the application form for couple of Indian origin, which means the couple where both husband male and wife female are overseas citizens of India. Cardholders, in accordance with the Act's rules, instructions, or guidelines being followed by the Ministry of Home Affairs from time to time, subject to fulfillment of various criteria as per the Surrogacy Regulation Act 2021, as introduced as Surrogacy Regulation Amendment Rules 2023, or an intending woman when for to safeguard the rights of the surrogate mother, the provisions for insurance coverage has been introduced, which mandates the intending couple or women to purchase a health insurance for the surrogate mother for 36 months. Further, it provides an affidavit before a metropolitan magistrate or a judicial magistrate of the first class shall be signed by the women or couple with intention of giving guarantee under Section 2 of the Surrogacy Regulation Act 2021, which deals with all the very definitions. The maximum number of attempts of surrogacy procedures shall not be more than 3 times. The surrogate mother shall give her free consent as per the specifications provided in Form 1. It has been decided by the gynecologist. Gynecologist shall implant only one embryo with an exception of 3 embryos in special cases. In case where a surrogate mother wants to abort the child, then abortion process is to be followed as per the Medical Termination of Pregnancy Act 1971, which already we have discussed in length in one of our previous lecture series. So now we'll discuss the very provision relating to the registration process of surrogacy clinics. So the first one that under the registration process that we would like to discuss, surrogacy clinics shall mandatorily register themselves with appropriate authority accompanied by prescribed fees, as it involves declaration of qualified staff, equipment, and procedure type undertaken by the surrogacy clinics. Further, if the application is accepted by the authority, then they will grant a certificate of registration as per Form 4 to the applicant. The applicant thereafter have to display the certificate of registration at a conspicuous place at its place of business. Further, in registration process, after the rejection or cancellation or suspension of application under Section 3 and such communication made under Section 14 of the Surrogacy Regulation Act 2021, the applicant has option to make an appeal within 30 days of such communication as per the provisions of Section 14 as per from appeal as specified in form number 5. Then further in the registration process, the national board or national registry or state board or appropriate authority or any other person authorized or empowered, and the surrogacy clinics shall allow them to inspect the place, equipment, and records. The inspection can take place at any time within working hours without any notice. However, such shall not endanger the embryo stored in the very clinic. So, in that connection, now we would like to discuss one important landmark case decided in the year 2022, that is Karan Balraj Mehta and another versus Union of India. So, a petition was filed by Karan Balraj Mehta and Dr. Pankuri Chandra with Delhi High Court challenging the banishment of a single unmarried man and a married women having a kid from surrogacy and requested the petitioner Karan Mehta contended that it is an individual choice of a single unmarried man without having a child through surrogacy, and they stand barred from using surrogacy as a reproductive option, which is discriminatory and against the constitutional provisions as per provisions of Article 14 and Article 21. Further petitioner number 2, Dr. Pankuri Chandra, has been made ineligible under the Act because he lacks a medical condition that would require surrogacy and is unable to find and receive consent from a qualified surrogate mother, and which is defined under Section 2 of the Surrogacy Regulation Act 2021. The petition contains that one aspect of the right to privacy which is protected under Article 21 of the Constitution, is the right to reproductive autonomy. Therefore, the right of protection of each and every resident or individual to be liberated from unjustified legislative interruption into issues generally influencing a choice to bear or hurricane through surrogacy can't be removed. So, now we would like to conclude our discussion on the very act, that is the Surrogacy Regulation Act 2021. As India is one of the significant center point of these practices at present, the act is surely a positive development, but there are few aspects on which laws and surrogacy stands contradictory. According to Article 21, right to life is a fundamental aspect, and right to reproduction has been embraced under it. The right for women to have children and the right to being a pregnancy to term are all included in their reproductive rights. Therefore, it is clearly a violation of Article 21 and fought into limit surrogacy while denying reproductive options. However, it is very crucial to maintain certain standards in the professions where risk to life of a person is involved. With the same motive, the central government or the union government issued the guidelines in the year 2023 to establish quality surrogacy clinics and explained the prerequisites that the surrogacy clinics shall comply with before providing the services in relation to surrogacy. In addition to that, some guidelines are also provided for an intending couple or women who are opting for surrogacy. With these measures, a protective process for a surrogate mother is created as evolving by those guidelines or rules relating to surrogacy rules of 2023. So we have completed the very lecture on this important piece of legislation enacted by the Union Parliament in the year 2021 as Surrogacy Regulation Act of 2021.